Yes, my lordship. I beg to mention with the consent of the other side, can this matter, item number 9, lordship, can this matter be fixed on Friday?
I'm appearing on behalf of respondent number 3, Your Lordship, Bar Council of India.
You are appearing for
A petitioner, lordship, PG for court.
the prayer of Learned Counsel for the petitioner
What
made
will
with the
this?
consent of the other side. This matter stands at 3 weeks.
Much obliged, Your Lordship.
Daily list for orders, item 1.
Please, Your Lordship.
Yes.
Lordship, in the last occasion, we were supposed to take steps, which we have taken it accordingly. But AD card of certain respondents have not been received yet.
So we'll have it. You're Mr.
A. Sarania.
Mr. S. Saranya, Learned Counsel for the petitioner submits that in terms of the order of this court, steps for service of notice upon respondent numbers 11 to 36 has been taken, but AD card in respect of respondent numbers 11 to 14 and 16 to 36 are still awaited. Mr. Ms. S. Kemprai, Mr. K. Gogoi, and Mr. And guys are present on behalf of the respective respondents. Registered to await service report on the aforesaid respondents. This the matter with appropriate office note after 4 weeks.
Obliged.
Item 2.
Please, Lordship, I'm appearing on behalf of Mr. P. Bodla. He has some personal difficulty today. Can you pass off for a day, my lord?
Made with the consent of the opposite. This matter stands regular to weeks.
Item 3.
Yeah, please, Your Lordship. Lordship, Mr. NJ Khataniar is out of station. Ma'am. So can it be after 20?
But what is the last order? The contempt case. You are appearing for whom?
Mr. NJ Khataniar. I'm appearing on.
Where is Mr. Katunian?
He is out of station, my lord.
All right, Tuesday. Mr. M.K. Hussain, Learned Counsel is present for the petitioner. Submitting that Mr. N.J. Katunia, Learned Counsel representing the sole respondent in this case is out of station. A request has been made to post the matter again in the next week. Considering the ground on which the prayer is made by the respondent's counsel, we direct the register to list this case again on next Wednesday. I don't think so.
Item 4.
May it please your Lordship. Lordship, this is appeal by Union of India, Lordship. Here I have taken steps, but for some address that return back, Lordship. Now I have given the correct address, but registry lodgement in letter is that I have to file an amendment petition. That's for that they have placed it before the honorable court. But a very minor correction. Only
You have to file an amended
yes, Lord.
cost rate. Ms. B. Sharma, Learned Counsel for the writ petition submits that due to some error in the address of the respondents mentioned in the writ petition, notices could not be served upon respondent numbers,
Sole respondent.
upon the sole respondent. Notice could not be served upon the sole respondent. However, upon obtaining the correct postal address, the petitioner intends to take fresh steps for service of notice upon the respondent number, sole respondent by registered post with AD. Ms. B. Sharma therefore seeks leave of this court to file amended cost item incorporating the correct postal address of the sole respondent and thereafter takes steps for service of notice upon him. On the oral prayer of Ms. Sharma, the request stands allowed. Within a week from today, amended cost title will be filed. On such event, we register to incorporate this in and thereafter steps for service of notice upon the sole respondent are registered post be taken, making the same returnable in 4 weeks.
Obliged.
Item 5.
Yes,
Your Lordship, the AD card has not returned the notice upon respondent number 6. I may be allowed to take fresh steps, Your Lordship, on respondent number 6.
anybody appearing for respondent number 6? No.
I'm appearing for the matter read prisoner,
You are for the respondent number?
one my lord.
The fresh steps within 3 days.
Yes.
Please see the council to the appellant submits that notice is yet to be served upon the respondent number 6.
My lord, nowadays these AD cards do not return generally. The post office it can be tracked also nowadays.
Mhm.
Even it can be tracked in mobile and also obtain the receipt nowadays.
What is to be done in this case? Acha, see thus learned counsel for the appellant submits that all those steps for service of notice upon respondent number 6 was taken earlier. No ID card has been received back. Mr. R.P. Sharma, learned senior counsel, listed by Ms.
AD card.
Eh?
ADECA.
A. Deka is present on behalf of the respondent number 1. The respondent numbers 2 to 5 are represented by 2 to 5 by Ms. So-and-so. Huh? A. Das. Mr. In view of the submission made by the appellant's counsel, let this matter be posted before the lodge
Your Lordship, the interim may be extended kindly.
so as to
Okay, so that's the-
if
my lord.
service, if presumption of service of notice upon the respondent number 6 can be drawn. Yes.
My lord, there was a bit urgency, my lord, in the case. It is regarding this headmaster or principal in charge, my lord. Can they take justice service, my lord? That will be better, I think.
No,
Justice service.
either steps to be taken or lodgement to take presumption. Which do you want? You can't have both.
Later take steps. Later take steps, my lord. But we want a bit urgent.
We'll take
That's why.
fresh steps on the respondent number 6, Your Lordship.
Lodgement na lage. On the request of the appellant's counsel, she is permitted to take fresh steps for service of notice upon respondent number 6, both by registered post with ID as well as by means of dusty. Steps within 3 days from today.
Much obliged, Your Lordship.
Lodgement part to na lage.
Item 6.
It is, Your Lordship. As per the office note dated 19/8, neither ID card nor unserved notice has been returned from respondent number 2 and 3. Respondent number 2 and 3 are branches of the State Bank of India, Senikuti and Ilpupuri branch, Your Lordship. It may be permitted to take dusty in that regard, Your Lordship.
See, only dusty is not
Yes,
permissible.
in addition.
So you have to take
Yes,
registered as well
yes.
as. Mr. M. Sharma, learned counsel for the appellant seeks leave of this court to take fresh steps for service of notice upon respondent numbers 2 and 3 by way of registered post with AD as well as dusty. Prayer is allowed. Steps be taken within 3 days from today, making the notice returnable in 3 weeks. I got to making the notice returnable in 3 weeks. List accordingly.
Item 7.
But discipline is barred by limitation by 8 days, Lord. Service complete, Lord.
All right. None has appeared. How many days delay?
8 days.
You control it. Mr. Dargupta, learned senior counsel, listed by Ms. A. Bhattacharya, learned counsel appearing for the applicant. None has appeared for the opposite party despite due service of notice. Mr. This IA has been filed under section 5 of the Limitations Act 1963 with a prayer to condone the delay of 8 days in connecting the preferred writ appeal. We have perused the explanation furnished in the IA. Uh, Having heard the learned counsel for the applicant and after taking note of the explanation for delay furnished in the IA, we are convinced that this is a fit case where the delay of 8 days in preferring the writ appeal deserves to be condoned. The delay is accordingly condoned. Office to register the connected appeal in list for admission, assistance displayed.
Item 8.
Lord, by last order, the government was directed to obtain the instruction, my lord, to produce the record rather. Because, my lord, that an impression was sought to be given as if in the pre-bid meeting, this issue was discussed. In fact, my lord, pre-bid meeting was held, but in that meeting, nobody has raised this issue. Because under the scheme of the general terms and conditions, if anybody has any query, that has to be uploaded in the website. Which has never.
You have entered appearance for whom?
For the private.
No, government was supposed to give the instruction, my lord. If your lordship will kindly see the last order.
Yes.
That's for number 3, my lord.
Yes, last order is dated.
Sorry. Huh? 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 Order the copy to Asil. Here. My lord, last order is 28-24. 28-24, my lord. While issuing notice, let notice be issued by so and so on next that learned respondent may produce the record.
Yes, who is for the department?
Lordship, senior is still stuck on traffic. It may be taken after some time.
Have you got the record?
No, sir. It's still with the file
Who is
with
your
the
senior? Who is your senior?
as Datta for PNRD.
So,
Let it be on Monday, let them have the produce the records, my lord.
all right. Mr. K. Chaudhary, that is Senate Council is appeared for the the learned departmental council representing the respondent numbers 1 and 2. Has submitted that this matter be posted again on Monday so as to enable him to produce the records as called for by this court. So, Mr. G. L. Saiwala, and senior counsel assisted by who is assisting?
G. Dugar.
G. Dugar, learned counsel has entered.
That's not
appearance
me.
on
Hello.
behalf of the respondent number 3, subject to placing Ukalatama on the record of this case. Registry shall list the matter again by reflecting the name of learned counsel for the respondent number 3 in the cause list. As agreed to by all the parties, this matter is directed to be listed
My
again.
lord, an undertaking was given by Mr. Dotto, my lord, in terms of the debriefing meeting. They will not issue the work order. I think they will abide by that. That was, in fact, that's.
Monday it will come. If it is there, it is there. Monday.
My lord.
On Monday. List on Monday, 9.
Item 10.
An appeal by the Diploma University, a delay of 13 days, my lord.
Notice has to go.
Today is the first time.
Heard Mr. R. Mahinda, learned counsel for the applicant. The applicant seeks an order condoning the delay of 30 days. 30.
1-3.
13 days in preferring the connected appeal. Issue notice returnable in 4 weeks. Applicant to take steps for service of notice upon the sole respondent. Applicants to take steps for service of notice upon the sole respondent by registered post.
I'm obliged.
Item 11.
Lordship, 224 days delay in preferring the appeal by Union of India.
Issue notice
Yes.
that Ms. B. Sharma and counsel appearing for the applicants. Sole applicant,
Sole applicant.
or you are not aware,
So applicants are many, but the respondent is one.
applicants. This IA has been filed under section 5 of the Limitations Act 1963 with a prayer to condone the delay of 224 days in preferring the connected appeal. Issue notice returnable in 6 weeks. Applicants to take steps by registered post with AD for service of notice upon the respondent, sole respondent. Making the same returnable in 6 weeks. Notice within a week, making it returnable in 6 weeks.
Item 12.
May I please your lordship? Your lordship, the conducting council, Mr. D. Gogoi is stuck in traffic, so it will pass over for the time.
My lord, time being or next week, Tuesday.
That timing also I have no,
Now, what is the matter? Is it,
my lord, regarding my lord that my stone cast message, my lord, the
no, you want to wait till the last item? That's up to you. But then we'll take it up as the last item then. Or you let it go on Tuesday. You decide, Mr. Savala, whatever you want.
let it be on Tuesday.
Tuesday. Mr. G. N. Savala and senior counsel has appeared on behalf of the appellate. However, yes. Who is your senior?
D. Gogoi,
However, it
standing
is
counsel.
submitted that this learned standing council forest department has not been able to reach court due to traffic congestion. On such count, a prayer has been made by the departmental council to pass over the matter. In view of the above, registry to list this case again on Tuesday, 10th.
Much obliged.
Revision item 13.
My lord, the matter relates to recruitment of demonstrators in the sericulture department. Now, my lord, rule does not envisage any selection process. Please come to the rules, my lord. At page number 145. Five three at page 145. It's a rule framed under Article 309, my lord. At page 145, sub rule 3 of rule 5, somewhere in the middle, recruitment to the cadre of sericulture demonstrators shall be made 100% directly from candidates who passed HSLC examination and also completed 1 year certificate training course in the sericulture from the Sericulture Training Institute till 96-97 batch I follow, my lord. But only thing is, I was under the impression that is the practice we are following. That's
That is the practice, but not in case where you want an injunction. This is a practice when you want a stay of the judgment on it.
No, we'll do
And
if
an
necessary. there's
adverse
no-
judgment is passed, which if operates will create hardship, so a stay.
180.
But when a petition is dismissed,
Ah.
there can't be any stay. When a suit is dismissed, there can't be a stay of that order.
No, I was only wondering, my lord, subject to what your lordships may say. Supposing lordship stays the order,
Hmm.
then the consequence should be the proceeding.
Please, Mr. Chaudhary.
No, we'll do, my lord. Henceforth,
See,
we'll do.
we want to come to the aid of your client. But sometimes these issues, and if it is not pointed out, then this is how it is going on. We are only concerned about whether it is the correct way or not. If it is correct, we'll do it. If it is not, we'll not do it.
I go to Meghalaya High Court sometimes. There is a requirement. There you have to file a separate IA.
If an injunction is being granted on a writ appeal, particularly when a proceeding is dismissed, with all respect to whichever bench has passed that order, that is a wrong order. We are willing to hear that matter whole day. It cannot be done. But if a petition is allowed with a direction, then what you're saying comes in. Then you want a stay of operation of the judgment. But here it is a case where the writ petition has been dismissed.
Well, we'll do that. There is no, only thing is, my
If
lord,
it
I
is
think this
dismissed-
should be made clear in the High Court. Anyway, that process is going on. I'll incorporate that now.
Please do it.
Yes.
Because these are
But
things.
our High Court rule is silent on that.
Which chapter you are referring?
5A, I think, writ appeal. Mention it, no?
And the reason is also simple. There
No,
has to be
I
a
quite see
statement.
that, my lord, but then I was only referring to the practice which we are following. 5A, no? Good. Huh?
At times, legal issues are technical, Mr. Chaudhary. What to do?
30.
5.
Ah.
5A.
5A. Rules governing application for direction order reads other than so and so. An application for direction or order read under so and so other than habeas corpus shall be drawn up in the form contained in the schedule to the and shall be accompanied by an affidavit verifying the facts relied upon. Separate applications will for each individual where interests are not identical. Provided that more than one individual can jointly file a single writ petition, each of them paying court fee payable on such application. In all other respect, procedure related to revision application shall apply to such an application.
No, you're right. That is when common writ petition is filed, common cause.
And
of
I
action.
will do that, my lord. There's no difficulty.
There has to be a statement made on affidavit that since 1/8/2008, no further progress has been made in the recruitment. Unless that statement is made, where is
And
the?
my lord, let the matter come up on Wednesday, we'll file it. I'll file the IA.
But if you are still
No,
willing to,
I followed.
if you're still pressing, then
No, my lord, what I'm saying is, I think time has come that we clarify that position in the rule itself.
Mr. Chaudhary, with due deference to what you are saying, this 5A operates in a different situation. That is when two and more people join together to file a common writ petition, not an appeal. 226. There, instead of filing separate petitions, they can join where there is a common cause of action.
Yes.
And in that case, they will have to pay.
No, my lord, I'm on this.
Yes.
Provided that more than one such individual can jointly file a single writ petition, one of each of them paying court fee on such an application.
That's
Giving me, my lord, this is what is being understood by all of us. That even lordships can check up in all writ petitions, there is no separate IFI.
No, writ petition is not
No,
required.
writ appeal.
No, if it is not filed, then it
No,
depends.
that's what I'm
It is a
saying.
stay.
That's what I'm saying. That is the practice we are following since 1993.
If it is a stay, fine. If it is an injunction, it's a wrong order. It's a
And
wrong
my
order.
lord, we'll continue, we'll do that.
Court cannot pass an injunction without a statement on affidavit. That affidavit has to be there. That this is what I am seeking. This is how my rights are violated. Because
And
otherwise,
Lordship is trying to bring that order 41, rule 5 and all.
not 41. It's the principles are of 39.
Okay.
But stay is 41. That's the difference.
Stage 41.
Yeah. 41, what you're saying, we accept. But 39, not permissible.
It
That's
has
the-
to be an independent application.
That's the difficulty. If it was a case of 41, immediately what you say, we'll accept.
But even in 41, there's a requirement of filing a
41, there is
separate
no
petition.
injunction. 41 is not injunction. 41, rule 5 is not injunction. But 39, rule 1 and 2 is injunction. So you please see that statement. Of course, the rigors are not applicable.
Anyway, what has fallen from your lordship is supposing the writ petition is allowed, somebody assails that action. Then
41 comes up. 41, rule 5. Then
but
what
when
you're
it
saying-
comes to seeking a stay,
Yes.
then order
The
spirit of
reason
order
is,
30, it's something like order 43, rule 1 are appealed along with a petition under order
Correct.
39, rule 1.
the reason is whether the order needs to be stayed or not is apparent from the order itself.
Anyway, we'll do that.
But in case of an injunction, what happened after the order is not before the court.
Anyway, we'll do that.
Nobody is taking responsibility.
Anyway, my lord, henceforth we'll do it.
But if you can make a suggestion if some changes are.
No, I think we'll have to do that. In fact, day before yesterday, I received a letter from the registry where they have asked for some suggestion. I think I'll put this on.
Yes, yes. Lots of things need to be changed. Otherwise, in future, it will create huge problem for the system. But then unless suggestions come, and these are matters, views are, invited. You can also argue that no, in case of an injunction also, no affidavit is required.
No, there's no harm, my lord. We are paying 10 rupee extra court fee. We'll put that court
It's
fee
not
in the
about-
petition.
It's not about court fee.
No, I'm saying
Hmm.
that the practice which is going on as on date, my lord,
Hmm.
for the interim relief, we have to pay extra court fee. That's the whole problem.
No, that interim relief, as I said, order 41, rule 5. That principle comes in, then it's fine. But if it is a case of order 39, rule 1 and 2 principle, then without an
I will
application.
do that. Let it come up
If
on.
that is not mentioned, then I think it's time to change. the
Yes, I think then there will be clarity, my lord.
On the request of Mr. K. N. Chaudhary and senior counsel appearing for the appellants, let this matter be listed again. When do you want?
Wednesday, my lord.
Wednesday. Wednesday is 12th, 11th of,
Oh,
11th of September 2000.
किधर दिन लेना पड़ेगा?
So as to enable the appellants to file an IA for an interim relief. Mr. Ardhar Lanet, Standing Counsel, Sericulture Department, Assam, is present on behalf of the state.
Item 14.
Perhaps my colleague had mentioned one matter, similar matters, which
12
fixed-
and 14, my lord, similar, my lord, can be taken up on Tuesday, my lord. On Tuesday, my lord, both are
10th.
similar, 12 and 14, my lord.
It is submitted at the bar that similar matters are fixed before the court on 10/9/2024, and therefore these cases be also, this matter be also tagged along with the other matter. On the request of learned counsel for both the sides, let this writ appeal be listed along with
Read appeal 278, my lord. Item number 12, my lord.
the 12 and 14 are fixed.
My lord, item number 12 is fixed on 10, and since the both item number 14 is also similar, my lord, I am taking it. It can be taken up on 10th. my lord.
Along with item number 12 on
Much.
All is much.
Item 15.
yes, who is appearing? None appears to the appellant on call. The matter stands passed off for the day.
Item 16.
Yes,
It is a rate appeal. I have earlier
you
filed.
can see that.
Yes.
Hmm.
I would like to brief the facts before the honorable court.
Now, which
That
order
I-
you're challenging? Which order? You're challenging which order?
I am challenging the final order judgment made in my writ petition, thereby disposing of my writ appeal.
Where is that order?
Page number 69. 68, page number 68.
Hmm.
Kindly see the order. The counsel who was presenting the writ petition on behalf of the petitioners has suddenly moved an additional affidavit before the learned on a single judge that I am withdrawing my wakalatnama and I am not representing him because I've earlier issued a communication letter in the year 2020 that he is not in communication with me. However, in the year 2020, that is of 11th of 2020, 11th November, ongoing pandemic situation was there. As well as kindly see page number 70. In the present writ petition, already interim orders were passed in favor of the petitioner, and the learned counsel for the respondents has stated on page number 70 that the petitioner is not paying dues since 2017, nor vacating the premises. However, I have placed on record certain receipts as per which, on the demand of the respondents, I am already depositing the present enhanced rent by demanded by the respondents. I am following the orders of the learned single judge. But still, in the absence of any counsel, the Honorable Court arbitrarily passed the orders that we are not following the orders of the Honorable Court.
So you cleared the dues.
I am clear till date, since 2017, I have paid all the dues except in the month of August. As on 3rd or 5th of August, the learned single judge has passed the orders dismissing my rate appeal, for which reason they are not accepting my enhanced rent.
What is the amount due now from your client?
As per me, earlier also I filed a rate appeal, in which rate appeal, at the time of passing the final orders disposing my rate petition, the learned trial court has himself mentioned that from the year.
But figure is page 91.
Page?
91. 89 lakhs, 68,642. It's a huge liability, my lord, dead. Payment.
Kindly see page number 59. The learned the learned honorable court has already mentioned that from the year 2nd of July 2010 till December 2016, the outstanding dues were only 8 lakh rupees. In the month of March 2017.
What is the due from your client at the moment?
At the moment?
Yes.
That's what I'm explaining to the honorable court, that
don't make these gestures to the court. Don't make it.
Oh, sorry.
You do it again, and along with your petition, you will go somewhere else. This is not a club.
Yeah.
What is your name?
Sir Sachit Sharma.
You don't know how to address a court properly?
Yes.
What is the amount of due now from your client?
Sir, they are demanding 89 lakh rupees.
Yes.
However,
what is the due according to you?
Sir, due according to me, I am paying rent as per the honorable court since 2017 till date.
What is the amount due?
As per my calculations, it was 8 lakhs as per the, and they have asked to bring the records. Till date, they have not brought any record before the honorable court. I am ready to pay till their, as per their quantification, it was 25 lakhs. And I am ready to pay 25 lakhs if they will brought the record and show me that 25 lakhs have to be paid till year 2017. Because after 2017 till 2024, I am paying the enhanced rent as per the directions of the honorable court. There are no delay or default on my side.
there is a clear-cut case, my lord, liability is huge, my lord, and my lord, they didn't pay the amount, my lord, and occupied the premises, my lord, without paying anything, my lord. Now, this practice is going, this has to be restrained, my lord, because newcomers are cannot, my lord, getting the accommodation, my lord. And they are occupying the premises without paying anything, my lord. This is big problem now we are facing. Second aspect also is the appeal itself is not maintainable. Only two issues I would like to address. Page 19 also we have seen it. Just see page 14 for a part, for a moment, prayer part. Page 14, prayer B, my lord. My lord, if you would like to agitate the notice, my lord, 28, 2024, my lord, better he has to approach before the learned single judge, my lord. It has not been answered by, my lord. Because that impugn notice he also put in appeal, my lord, which perhaps, my lord, he cannot, my lord.
Sorry, what is
My
it?
lord, the impugn notice that we have issued subsequent to the order, that is 20 August 2024, claiming certain amount. Now he also put under challenge in writ appeal, my lord, page 14. In my view, my lord, this notice, if you would like to agitate, my lord, then he has to go before the learned single judge, my lord. Second aspect, lordship, this petition has been filed by the company, my lord. Just look for a moment, my lord. Page 2. Page 2, my lord.
So we'll have to examine, we'll ask him to deposit amount. How much?
And I'm ready to deposit if they will.
25 lakhs.
25 lakhs, I'm ready to deposit.
We'll deposit 25 lakhs. We'll examine the matter.
Yes.
Lordship, so far our liability is concerned, no doubt, Lordship, quite right that if we inclined to suppose 25 lakhs, my lord. So far our calculation is concerned, my lord. I don't feel that any errors are there because, my lord, whatever norms are there, my lord, about calculation of interest, penalty, etc. Everything we have done, my lord, in accordance with, my lord.
And a single judge has also given him that liberty to deposit the amount.
Yes, my lord, but he
Failed
failed to do so, my lord.
Huh?
He failed to do so, my lord.
By which time will you deposit?
The day they will bring the record, and if there is
Nothing. You have to deposit the amount will be subject to further orders of the court.
My lord, can you see?
They will deposit the amount within 18th of September. If they fail, you proceed to evict without any further reference to this.
and
Heard, Mr. Your name, please?
Sachin Sharma.
Sachin Sharma, Learned Counsel appearing for the writ appellant. Also heard Mr. S. Chamaria,
I am representing
Standing Counsel EIDC appearing for the respondent numbers.
all respondents, all respondents.
All the respondents, full stop. This writ appeal is directed against the order dated 5/8/2024, passed by the learned single judge in WPC number 1973/2017, whereby the writ petitioner stroke appellant was granted 1 month's time to clear all its dues for occupying the industrial shed of the AIIDC, failing which liberty was granted to the authorities to evict the writ appellant stroke writ petitioner. We put it in that order, writ appellant writ petitioner from the industrial unit occupied by him, besides granting liberty to the authorities to initiate proceeding for recovery of the dues. Full stop. In the order dated 5/8/2024, the learned single judge has observed that a sum of rupees 25 lakhs 03,692 is due and recoverable from the writ appellant as per the claim of the authorities. Mr. Sharma, learned counsel for the appellant, by referring to the observations made in the impugn order, submits that his clients have been regularly paying the amount due until date, a sum of rupees 8 lakhs. 8 lakhs is only due.
Yes.
Is only due. Full stop. According to Mr. Sharma, once the records are produced before the court, the aforesaid fact will be established. The learned counsel for the appellant has, however, submitted that for an order of protection from this court, the appellant will be ready and willing to deposit the amount directed by the learned single judge as an interim deposit. Full stop. Responding to the above, Mr. Chamaria submits that if the appellant deposits the amount reflected in the order of the learned single judge, then his clients would have no difficulty in permitting the appellant to continue to occupy the shed, subject to final order passed in the appeal. Full stop. Having heard the learned counsel for both the sides, we are of the view that the matter would call for further examination as such issue. Notice returnable on 25th of September 2023-24. Since Mr. Chamaria has appeared and accepted notice on behalf of all the respondents, no formal notice is required to be sent in this case. Extra copy of the memo of appeal be furnished to the learned standing counsel within 3 days from today, heard on the prayer of interim relief. Having regard to the facts and circumstances of the case, we hereby provide that subject to deposit of the amount of rupees 25,03,692 by the appellant with the respondent AIIDC on or before 20th of September 2024. The appellant shall not be evicted from the demised premises. Full stop. It is, however, made clear, shall not be evicted from the industrial unit under its occupation. Full stop. It is, however, made clear that if the appellant fails to deposit the amount with the authorities on or before 29/2024, it will be open for the respondents to proceed with the eviction of the appellant without any further reference to this court. Full stop. Deposit the amount so and so by means of bank draft public check.
My lord.
The deposit so made will be subject to final order passed in this written.
Item 17.
Make visual lordship. The petitioner is a freelance investigative journalist.
Mr. Das begins, I had a small prayer, considering the seriousness of the issues raised in the petition.
It's very serious.
It is the destruction of the habitat, destruction of Kaziranga National Park, where the international tag might be removed anytime. Because the central government is supporting my case. They have been urging the state government for 18 years that in compliance of the Supreme Court's order, you notify the eco-sensitive zone. They don't notify, they send proposals on 3 occasions. Today, what has happened, the central government has come up with a category. I won't take your lordship to this voluminous petition. The expert committee of the central government has directed that don't give us fragmented proposals. We want integrated, because what has happened, the northern area of Kaziranga is the floodplain. The southern area is Karbi Anglong. The linear obstruction is the road. Now the one-horned rhino will be totally wiped out because during the monsoon time, they go to the highlands. Now Karbi Anglong, basically massive mining is going on and Supreme Court's order is there. I'll just take your lordship to some, well, it's a very serious
What
case.
order are you seeking today?
Well, today I'm seeking a notice, and in terms of the Supreme Court's order, they have to comply. They have to give an inventory of all the corridors around the national park, because unless that comes, and that will not come from a ranger or a DFO, it will come from the Chief Wildlife Warden of Assam, who will give and that's a Supreme Court's order, the government's latest case. That is the thing I want.
My question was that considering the seriousness of the issues involved, the state had requested Mr. P.N. Goswami to appear. He's in some difficulty, but
He has sought for
Mr. Das, will take up your matter, but there is no need to, oppose this prayer. We'll put it on the green bench next week.
Very
Thursday.
Yes.
Thursday, green bench.
Can it be on?
Green bench is only on Thursday.
I'm on, because he took permission from me last night. I told him that the notice part will go, and since I'm out of station next week, can it be on Monday, Lodge? But at least the notice may go. That can be. I'd already informed him last night, and he agreed to it. He coming in doesn't make, because he's appearing.
My instructions are, Your Lordship, the issues which have been raised, fundamentally those issues are still pending before the Honorable Apex Court. Because the orders which have been referred to in the petition, the Honorable Supreme Court is still in session of the same subject matters. And in fact, IAs have been passed for clarification of those orders, and those matters are also pending. So perhaps some consideration will be required on
Alright,
whether.
Malad,
Mr.
I'll
Das,
show, yes,
Just
I'll,
a minute, just
yes.
a minute. When you are out of station when?
Malad, I'll be leaving towards the end of the week, next week.
Towards the,
And on Friday.
on
So
Friday?
Monday, I'll be there. Can it, if your
No,
lordship.
if you're
accept-
leaving on Friday, we'll have it on Thursday before the green bench.
Yes.
Yes.
Only Malad, this point I need to counter. The Supreme Court is seized over the matter, but the Supreme Court in this case has clearly stated if connected matters are taken up by the high courts, they can issue orders which will not be contrary to Supreme Court. So this bar cannot work because your lordship is exercising power under 226. It's an extensive power in Article 32.
So put the name. It appears that the PIL raises serious issues concerned with the environment and therefore is a matter pertaining to the green bench. First of registered on the request of learned counsel for the parties, registry to therefore list this matter before the next green bench.
Yes. Malad, it will be on Thursday, lordship.
Green bench is Thursday, 2nd of.
Obliged, lordship.
Green bench to within court. So
Item 18.
Lordship, this is the PIL pertaining to land acquisition in Dima Asau without following any procedure of law, Lordship.
how many more on the same subject? How many are there already?
Already two has been dismissed by the division bench of the Honorable Court, lordship. Two has already been dismissed.
Lordship, we had filed a RTI. Then they replied saying that the 2013 Act does not apply in Dima Asau, Lordship.
Where is the order of the division bench? Do you have it?
Lordship, I can provide, lordship. I can provide.
Why don't you give him a copy
Lordship, I
of the
will,
order?
I will,
You go through the order and see.
Lordship.
If it's
Lordship.
covered by earlier order, then we'll have to pass an order here.
Yes, lordship.
You understood?
Lordship.
Earlier, similar matters were dealt with by the division bench.
Lordship.
So you go through the order
Lordship.
and see whether your matter is covered or not.
Yes.
All right. Heard Mr. A.I. Kathal and counsel for the petitioner. Mr. R.M. Das, Lanet standing counsel. You have for NCL's
NCLs.
autonomous council submits that similar writ petitions, bracket PILs, have already been disposed of by this court. And therefore, this PIL is not maintainable. Full stop. On the request of Mr. Kathar, this matter stands adjourned for a week so as to enable him to examine the earlier orders passed by this court on similar issues.
Lordship, it will be taken up on Monday, Lordship.
You go through the order.
I will go through, Lordship.
Are you in a hurry?
Yes, Lordship, because they have already entered our plan, Lordship.
Okay. Next week.
Item 19.
May I please, your lordship? The appellant and the respondents, my lord, they are brothers. There was a dispute regarding the possession of possessor rights. Possessor rights. Now what?
Which order you are challenging?
We're challenging the order, the imperial order, my lord, that is passed by this. That your lordship will find judgment and order dated 72/2012, page 92, my lord. Already position was declared in my favor by 145 proceeding, my lord. And the honorable single judge also has come to a finding that I am in possession, my lord. The last line is creating trouble because they're forcibly entering my residence, creating problem, my lord. Because earlier there was a status quo order, my lord. And that's your lordship may kindly come from paragraph 12, my lord, page 96.
And where is the order dated 17/5/2015?
17 file. That is your lordship will find at page 78. 79 to
Page 70.
78.
Okay.
It's part of the writ proceeding, my lord.
And where is the order dated 2/3/2010 of Munsif?
Munsif order, your lordship find that there was a miscase, my lord. And the miscase was dismissed. That your lordship find it is 2, 3, no, it's 4, 3 actually. There is annexure 3, man.
Page number?
Page number 49, man. Operative part is 52, man.
Who was the petitioner in this case? Who was the plaintiff?
Now, plaintiff is the respondent. I was the plaintiff.
You are the plaintiff. Your application has been rejected.
Rejected.
And then the order was passed by the
Yes,
to hand over possession.
yes. My lord, the order declaring possession by the executive magistrate was of 2001. Based on that, my lord, the disposition notices come in 2008. If your lordship kindly comes to the honorable single judge's order, my lord,
Who is in possession of the land?
I am in possession.
No, actually, that is it. I'm in possession because they want possibly
Yeah,
enter.
we will have to examine it, but prima facie, there is nothing wrong with the order of the land and single
I'll
judge.
satisfy your lordship.
Status quo, you might.
Yes, that is important. That is earlier read petition was that's for over there.
There is no prayer for interim, my lord. There is no IA file in the case.
They need a yeah, your
Anyway, I'll leave it to your lordship's, my lord.
Acha, what is your prayer for interim relief?
interim lead by status quo order, my lord.
That will not pass if there is no IA.
Because he in the main
No,
case.
no, that will not pass.
I will file a
File an IA. When do you want to file it?
by Monday.
Either you argue that it is not required or you file it.
Yes, I
Don't say that it is required, but I will not file it. That
I
stance will
understand.
not accept,
Yeah.
will not be accepted. We'll follow the law as
Yeah,
much as
understand.
possible. If we can't sometimes and it is a
Actually,
very, very difficult case, then it's another thing.
Yeah.
You want an injunction. You want an injunction, which you may be entitled to. But you
because earlier in the writ proceeding also there was an order of status quo. That actually that
the
created
morning-
problem.
I think Mr. Ken Chaudhary was there. His court has had enough discussion
understand.
on that. You want an order of injunction, not
Yes.
an order of stay.
Yes,
If you want an order of stay, but you will not get any benefit out of it.
yeah.
So what do you want?
Sometime I'll file it
Next week?
next week.
Let it come. On the request of Mr. P. Kotakil, learned counsel, let this matter be listed again in the next week so as to enable the applicant to file an application seeking an interim order of injunction so as to protect his possession over the disputed land. Mr. N. Decker, learned counsel, is present on behalf of the respondent number
5 minutes.
Respondent number 5, whereas Mr. N. Das, learned government advocate Assam, has appeared for respondent numbers 1 to 4.
1 to
Or you don't know? You don't know? Please take on it.
May I please? My lord, the order passed by the anti-administrative tribunal is under challenge, my lord, whereby the tribunal has quashed the my lord, memorandum of charge sheet, inquiry report, order of penalty, and my lord, the advice of the UPSC. My lord, the impugn order, the relevant portion of the observation by the court, my lord, is at page 29. Lord, basically on 2 grounds, my lord, the tribunal has interfered. First is on the ground of delayed initiation of the disciplinary proceeding.
Which page you are referring?
My lord, page 29. Paragraph
20.
9.
Yes.
Paragraph 9. Heard the Leonard Council of both the parties. We produced the relevant documents on record and went through the judgments. It is settled principle that all disciplinary proceeding must be initiated and concluded expeditiously. Disciplinary proceedings cannot be initiated after a lapse of considerable period of time. It is not a fair to a delinquent officer. Such delay also make the task of proving the charges difficult and thus also not in the interest of the administration. Delayed initiation of disciplinary proceedings is bound to give room for allegation of biasness, malafidness, misuse of power. If there is a delay, it is too long and unexplained, the court may well interfere and quash the charge. Now, this was the first ground, my lord, and the second ground, my lord, is at page 32. Page 32, my lord, in the beginning itself, my lord, also.
All right, we'll issue notice.
My lord.
Heard Mr. Gupta, learned CGC. CGC appearing for the rate petitioners. This rate petition is directed against the order dated, judgment and order dated 15/3/2024, passed by the learned CAT Guwahati bench in OA number 040/0378/2018, issuing certain directions to be complied with by the petitioners. First up, we have perused the impugned judgment and order. First up, issue notice or motion returnable in 4 weeks. Petitioners to take steps for service of notice upon the sole respondent by registered post with AD within 3 days from today.
On the interim pair also, my lord, the next day, my lord,
Hard
interim-
on the prayer of interim relief, the said prayer will be considered on the returnable date.
Which one?
21, my lord, may I pray for some time, my lord, 21, my lord, it may come up some other day, my lord, I have not prepared, my lord, item 21.
You want it to be on some other day?
My lord, my lord.
On the request of Mr. H. Gupta, learned counsel for the writ petitioner, this matter stands passed over for the day so as to enable him to prepare and argue the matter.
Item 22.
My lord, in item 22, my lord, the respondent's hearing, my lord, has initially preferred an application before the tribunal, my lord, challenging the order of the transfer. My lord, that order of transfer was initially stayed by the tribunal And my lord, during the pendency of the stay, my lord, that stay continued for, my lord, around period of 2 years. Now, my lord, subsequently, what has happened, my lord, the petitioner has applied for a fresh request for the transfer. And the first, my lord, the initial OA which the petitioner has filed, my lord, that has become infructuous. Now, my lord, the petitioner, by filing a subsequent, my lord, OA, claimed that, my lord, during the period of the stay, my lord, the arrear salary ought to have been paid to the petitioner. The respondent authorities, my lord, in the postal department, they denied payment on the ground of no work and no pay. My lord, that is the basic case, my lord. The petitioner, my lord, it was the choice of the petitioner, my lord, that subsequently he made a fresh representation and he got posted to a, my lord, subsequent place of posting. So, my lord, that intervening period when the stay order was operating, my lord, the petitioner neither joined the department nor, my lord, worked, my lord, for the department. He was sitting idle, taking, my lord, preparatory leave. My lord, that is the basic, my lord, contention.
All right,
of
we
the
need to
respondents.
notice the same thing on the
No.
interim also.
No.
Heard Mr. Gupta Learned Counsel appearing for the writ petitioners. Peruse the amendments made in the writ petition. This writ petition is directed against the impugned order dated 04/06/2024 passed by the learned CAT Guwahati in OA number 222/20220 and connected OA number 14/2023, issuing certain directions to be complied with by the writ petitioners. First up, we have perused we have gone through the impugned judgments and find that the matter calls for consideration. First up, issue notice returnable in 4 weeks. Petitioners to take steps for service of notice upon the sole respondent by registered post with AD within 3 days from today. Hard on the prayer of interim relief, this said prayer will be considered on the returnable date. Supplementary matter. Yes.
Lordship, this PIL has been filed by Kihu Kunda Nigam Committee. There's a society there. Their basic grievance of the society is that one retail outlet of petroleum, I mean like petrol, has been set up adjacent to the school, wherein students, the strength of around 600 are studying. And like it has been, they have violated while issuing the NOC because they haven't inquired into the matter whether school is there, hospital is there, they have violated that. And secondly, like while after filing of this writ petition, one fact has come to the light that this person has given some fake documents, fake certificates to obtain this retail outlet. That has come into fore, and like actually, as per the company's guidelines, the person has to pass 10th standard. It has to pass. But see, the person who has got this retail outlet, she has failed it. She has come before this court.
Who is appearing for the private respondent? Is there a private respondent in this case?
Yes, madam. Respondent was
Yes,
second,
yes,
but
Who is appearing?
last time, madam, P. Mohanto was there.
Mr. Mahanto, P. Mahanto was.
And again, he says, madam, the earlier council.
Mr. P. Mahanto was appearing. Yes. And also NOC was given without inquiring into the matter, violating the statutory norms, violating the statutory forms.
Kindly see 131, madam, for a moment, madam.
But why are you arguing, first of all?
No, no.
Why should we hear you?
Yes.
You cannot just decide that we'll argue the whole case and then say, post it on another day.
No, I'm not.
Is it to be taken up for final disposal?
Because pleadings are complete.
Where is the other side counsel?
Sir, counsel, last time he was there, now Lordship, I'm not sure.
Then what happens is we pass a judgment, then a review comes after 4 weeks. And we have to do the same work again. So why don't you call him, Mr. Mahanta?
Mr. P. Mahanto.
We'll consider after some.
Lordship may take it up after some time. We'll try to.
Fresh matters you call first, no? Admission. Fresh matters, supplementers you have to call first, along with these are all fresh matters. to 22 are fresh matters. Then continue with the fresh matters. Yes.
Supplementary list for admission, item 27.
Made future lodging. And not the petitioner is basically a consultant in respect of an NHIDCL
Mr.
project.
Chaudhary, I think it's a company from Gurgaon. Your client is from Gurgaon. Gurgaon.
Yes, yes.
For some personal reason, I would not like to take up the matter. Perhaps you are aware of the reason.
Okay.
Want it on Monday?
Monday.
Monday?
Yes, Monday or what? Monday.
List this matter before any other bench without one of us, bracket my name. On the request of Mr. Chaudhary, let this appeal be posted for admission on Monday, that is 9th.
38.
My lord, this is a matter where BSNL authorities are before your lordships. That happened, my lord, if your lordships would kindly come to page 177.
But it's fixed on 9th.
Yes, my lord.
Matter is fixed on 9th before the CAT. Before the tribunal, the next date is 9th.
9. But my lord will kindly see. Kindly see, I'll just take 5 minutes time. Therefore, if your lordship feels, then it's otherwise. Please come to page 177. Now, my lord, the applicant respondent before the tribunal, he belongs to civil stream. Now, this post is to be manned by, my lord, telecom stream people, ITS people. Now, erroneously, a panel was empaneled. Now, pursuant to that, amongst others, 9 officers were given posting as Chief General Manager. Now, all these 9 posting has been recalled now. Now, the most important part is, if your lordship will kindly come to the rules, a rule is at page number.
So, Mr. Chaudhary, what is the order you're seeking?
I'm seeking stay of this order because they've initiated a contempt proceeding.
When is the matter fixed?
No, my lord, he handed over charge. Thereafter, suppressing this fact, 9th.
Follow it.
9th, it will not take place because there will be no division bench. Because the other side would like to say, this is a matter of, my lord, not a per se transfer or a posting. It's a case where reversion is involved. Therefore, as per the rules of business of tribunal, my lord, it has to be posted before a division bench. There is no division bench. And they have initiated a contempt proceeding.
When is the contempt?
13th, they fixed it on 13th, my lord. No, lordship will kindly see. My lord, we empaneled, yes, but we committed a mistake. That's what I'm trying to show. Please try, allow me to place these rules, my lord. Please come to me, lord, page 78.
Contempt is by the CAT, before the CAT.
Yes.
So, Mr. Chaudhary, you argue your matter,
Yes.
but we are telling you the order will pass.
Yes.
What will post the matter on 11th, saying that pendency will not be a bar for the learned CAT to pass a final order in the MA. If for any reason the matter is not taken up on 9th or no final order is passed, then it will be open for the appellant to press for an interim relief before this court on the next date fixed, 11th. That's the order will pass. I think that order will.
Well, I was just trying to show one thing. I'll please give me 1 minute time.
Yes.
Please come to page 85, my lord.
You may have a good case in there.
No, in fact, it's a
The
case.
point is, the order of the CAT clearly shows that on the last occasion, I think there was some virtual hearing which took place and they were not. No, maybe there could be
So,
some.
my lord, question is, he does not belong to that cadre. My lord, administrative authorities always have power of review. if a wrong order is passed, can't it be corrected?
No, you are absolutely right, but is it not necessary that the CAT passes an order on that, this way or that way? Why should it preclude the CAT from passing that order?
So my lord, question is, the matter was heard at length on that day, particular day. Instead of vacating the order, the matter was fixed for hearing.
So hearing is on 9th.
Ah.
So we'll clarify that on 9th, if for any reason the matter is not heard and no final order is passed, then it will be open for the appellant to press for an interim order in this case. We are not disposing of this.
Only thing is, my lord, just one page
But
thereafter.
we will
not
not
sending
stay
it to
the
your lordship.
proceeding before.
No, I'm just, please
Yes.
come to page 85, clause 6.
Yes. Not non-suiting your client at all.
No, I follow.
And we
Please-
understand your.
Please come to, yes, note 6, my lord. Last 4 sentence.
Page 86,
Page 85.
85, yes.
This is a part of the rules, my lord. Last 4 lines. Chief General Manager, Principal General Manager level post shall be filled up from regular ITS, HAG and HAG non-functional level ITS officers deployed in BSNL who have entered in 27 years of service as on 1st January of the year, calculated from the year following the year of examination, on the basis of which such officers has been recruited in Department of Telecom. Well, he's a civil stream officer. Now, my lord, along with him, 8 other officers were also transferred. Now, all have been reverted back. Kindly see, my lord, the order in respect of the others at page number 191, my lord. First, if your lordship will kindly come to the order by which they were transferred.
Yes.
Page number 178. Kindly see, my lord. 17, order to come to place 182, my lord. This was the posting order which we have recalled now. Kindly see page 182. There are 9 officers. Now serial number 6 is the applicant before the tribunal. Now, my lord, will kindly come to 191. Sorry, 190. Now kindly see Anita so-and-so, Devendra Kumar Agarwal, Binay Kumar Sharma. These are 3. And at page 191, Nirmal PG, Ujjal Gulhane, so-and-so Venkateswaralu, Mane Mahesh Chand Singh, Papu Sudhakarao. These are 8 and applicant is 9. All have been posted back. Now, one of the ground before the tribunal was he was picked up for discriminatory treatment. Now, all have initially he was started with, and in the continuous process, my lord, all have been reverted back. Now, that empanelment was wrong because this is a cadre post for ITS officers. I've shown the rules. But in spite of that, the tribunal does not vacate it, my lord.
No, we'll protect the interest of the BSNL.
Meanwhile,
But
my
we're
lord,
not
will-
staying the proceeding before the tribunal.
on 11.
On 11, we'll fix it,
Yes.
making it clear that if that is a MA number 95 of 2024 is not finally disposed of, and if no final order is passed on or before the next date fixed, it will be open for the appellant to assail the order in this proceeding and also pay for an interim order in view of the pending contempt proceeding. So if you don't get it there, you'll get it here.
The
Probably.
only thing is, my lord, now what is there in this case?
No,
my
but that the problem is we also have to maintain a
So
discipline,
this is not a
judicial
question of
discipline.
preempting, my lord. It's not that straight away against the order we have come. We have filed an MA. The matter was heard at length. What was there to be not decided on that day, my lord?
That question will become very, very prominent if on 9th the matter is not taken up. It is convenient, but
No, my lord, on 9, actually, my lord, because of the official procedure, we took time. Otherwise, immediately we could have come. I know. Today we have come very late because the earlier it was last. But only my submission is, my lord, here is a case, what was there for tribunal not to take account?
That's correct. But when the matter is fixed on Monday, what is the earth-shattering urgency for the High Court to take up the matter? If that question is asked, then
No, question is, if a prima facie case is made out, then normally lordships will take note of it, my lord. That's what I was trying to say. And if we go by, my lord, section 11, explanation 5 or 6, if a prayer is made, if a prayer is refused, then my lord, I can't even make that prayer again.
no, in the order, please see the order.
I've
Page,
seen it.
page 32. Page
No,
32.
I've seen it, my lord. The tribunal was of the view for ends of justice. What was the ends of justice? The matter was heard for more than half an hour.
That is a different. We are closely scrutinizing the orders.
And
of
my
the
lord,
CAT.
this contempt proceeding, that should be kept on hold.
What is the contempt case?
Yes, notice from it. যখন বিচার
Contempt is against the order dated 30th of July.
Yes, yes.
So, Mr. Chaudhary, 11th you are available?
Yes.
11th we'll do it, and we'll also observe that final order is to be passed.
Yes.
And we'll give you the liberty, if any order is passed and you are agreed, you can file an additional affidavit and bring it to the record. Heard Mr. K. N. Chaudhary, Learned Senior Counsel, and Mr. G. Goswami. You're there, Mr. Kalita, you are also there? Counsel appearing for the writ petitioners. This petition is directed against the order dated 37/2024, passed by the learned Central Administrative Tribunal, Guwahati, in OA number 182/2024, suspending the operation of the interim order of reversion of the sole respondent dated 19/7/2024, as well as the order dated 13/8/2024, passed in M A 95/2024, whereby the prayer for vacating the ex parte interim order dated 30/7/2004 has not been finally considered and disposed of by the learned tribunal. Full stop. Mr. Chaudhary submits that this is a clear case where there has been reversion of the order of promotions earlier granted.
Not reversion of order of promotion, posting.
Reversion of order of posting earlier granted to all the 9 departmental officials, including the private respondent. Notwithstanding the same, on an erroneous projection of facts and misrepresentation of a case of violation of fundamental right and principles of natural justice, the respondent has approached the learned CAT, whereby the interim order dated 37/2024 has been issued, thereby causing enormous disruption in the functioning of the BSNL. Full stop. After going through the materials available on record, we find that by order dated 13/8/2024, passed in MA 95/2024, the learned CAT had fixed the matter on 9/9/2024 for final hearing of the miscellaneous application, praying for vacating the order dated 37/2024. Full stop. If that be so, we are of the view that
Along with the main appeal.
Along with the main application. If that be so, we are of the view that the writ petitioners should pursue the prayer in the MA number 95 of 2024 before the learned CAT, before um, before agitating their grievance in this appeal. Full stop. At this stage, Mr. Chaudhary submits that a contempt case being case number. What is the contempt case number?
Yes, my lord. This is CP number 40 of 24.
Being CP number 40/2024 has already been instituted against the petitioners, and the matter is now fixed on 13/9/2024. As such, there is an urgent requirement for suspension of the order dated 30/7/2024, passed in OA number 182 of 2024. Full stop. Having heard the submissions made by learned senior counsel for the writ petitioners, we direct the registry to post this writ petition for motion hearing, no, for admission hearing. Again on, is it for admission or motion?
Admission.
For admission, again on 11/9/2024 as a fixed item. Full stop. During the pendency of this writ petition, it will be open for the learned CAT to proceed to hear the MA number 95 of 2024 and pass final orders therein in accordance with merit. Full stop. It is, however, made clear that if for any reason the MA number 95 of 2024 is not finally heard on 9/9/2024 and no final order is passed therein on that day, it will be open for the writ petitioners not only to assert their claim in the writ petition, but also seek an interim order of stay so as to, in the interim order of stay in view of the pending contempt proceeding. List accordingly.
If
Have you been able to take down? Huh? Who know it?
Item 23.
He is appearing.
You are appearing?
Yes. Yes, and respondent number 7.
Okay, so what, this matter is to be heard finally. Mr. Kalita will not hear it today. No final hearing today. On a Friday evening, we can't do.
No,
final.
no, absolutely.
You
fine.
can
No
choose a
problem.
date.
Some other date.
Huh?
Some other date, no problem.
But pleadings are complete.
Pleadings are okay.
Mr. A. Kalita, learned counsel for the petitioner, as well as Mr. S. Bothakur, learned counsel appearing for the phone number.
4 minutes.
Please find out who you are representing.
4
This
minutes.
is the minimum you.
4 minutes.
For
That's enough.
4, you have 4. Mr. U.B. Sharma, learned counsel for respond number 7. And Mr. N. Das, learned counsel for respond numbers 5 and 6 have submitted that this matter is ready for hearing and can be taken up for final disposal. Full stop. The learned counsel for the remaining respondents are not present. Full stop. Considering the nature of issue involved in this petition and the urgency expressed in the matter, this petition is directed to be listed for final hearing on. When do you want it, Mr. Kalita?
23.
Tell us a date.
23rd.
Or a non-miscellaneous day, 23rd.
Yes, ma'am.
No, not after vacation. On 24th or 23rd, Lordship, 24th, as per the convenience.
Non-miscellaneous day, 24th. 24th of September, 2020.
Obliged. This writ petition filed by the Income Tax Department, assailing the order dated 14/3/2019 passed by the learned CAT.
It's a writ petition or writ appeal?
Writ petition passed by the CAT, whereby the respondent was granted higher pay scale of with a grade pay of 4,800, but the rule doesn't provide for that. Earlier he was serving in the Air Force Lordship. Thereafter, he was appointed in Assam Income Tax Department as a senior grade translator also. And the rule doesn't provide. And the
So today it has come for what? You are filing affidavit?
they were
No.
supposed to file
Lordship,
affidavit.
we have already filed the affidavit yesterday itself.
Lordship, I have not received any copy. Lordship.
But I'll be serving the copy from the
Sir, sir, copy. When did you file?
Lordship yesterday.
Had Mr. S. Kyle and a counsel appearing for the writ petitioner. Writ petitioners, Miss
A Das,
A.
Lordship.
Das, learned counsel appearing with the sole respondent submits that counter affidavit on behalf of our client has been filed in this case only yesterday. However, Mr. Kyle has not received the copy of the counter affidavit. First of all, moreover, it appears that the counter affidavit filed yesterday is also not tagged in the record of this case. In view of the above, let this matter be listed again after 2 weeks by taking the counter affidavit.
Lordship, I
of the
pray
record.
for a few weeks time. Maybe it may matter be fixed for hearing for the next month.
Come. That is it.
Item 25.
Please, your lordship. Lordship, I have filed an affidavit in reply, but it's tagged, but I have filed yesterday, lordship.
You filed affidavit in reply.
Yes, lordship.
You are the petitioner.
Yes, lordship.
What is this PIL about?
It's also regarding regularization of 500 contractual employees in the GMC, lordship.
They are
So
basically
it was-
against the regularization of the 500 numbers of employees.
Against.
Not, they were not, this one, they were regularized without taking the approval of the finance department, lordship.
But
And
who are you? How are you bothered?
lordship, here I am the, this one, I'm a social activist, lordship. So
What business you have filing this PIL?
his lordship here, this one, I'm involved in various, the petitioner is involved in various social welfare at large, lordship, and also he has filed a complaint before the officer in charge of vigilance and anti-corruption also regarding all this. Regarding lordship, the petitioner, he has filed several PIs also, which is even here in this. Pending.
So regularization is done by the department.
Yes, lordship, but
Then why action should be taken against the officials?
lordship, it is incomplete by this regularization is in violation of the law which is laid down in the, by the Honorable Supreme Court in the case of.
Raise that plea in
Marketing
the assembly.
And
We're
also,
not
lordship,
entertaining
complaint
this.
has been filed, lordship.
3 minutes to complete your arguments. We are closing this PIL. These are
Lordship.
all frivolous matters.
Lordship, not today, lordship, that my reply in affidavit, my reply also come, my lordship may fix in next week, lordship.
You have no business filing this PIL.
The affidavit is also
No,
not common.
the PIL is being misused. And
No,
it's being
lordship.
misused heavily in this High Court.
Lordship, at least not in this.
No,
case.
what is your business questioning the regularization of 500 employees? Who are you?
Lordship, yeah, this petitioner, he is in, he's basically, he's a wholesale fish trader.
He's a wholesale fish trader.
Yes, lordship,
And he is questioning the regularization of service of
and
employees.
he's involved in several social activities also, lordship, in this petitioner, lordship.
Yes.
And several.
Which other department he has questioned the regularization?
Yes,
Where
there
is
are
the
also
pleading?
other PIs which is involved in regarding the PHE and also Assam fisheries development, which is pending here in this court, lord.
Tell him to sell fish and not bother about legal issues. In which other department has he looked into regularization? There are complaints of illegal regulation in all departments almost.
Regularization.
Why only GMC? Whose agenda is he pursuing?
No, Lordship, there is also even in Assam Fisheries Development Corporation also one PI has been where Lordship has passed order, Lordship, in this court.
Yes, what do you have to say, Mr. Naik?
Lordship, under certain circumstances, Lordship, a decision was taken to regularize 500 numbers of employees, Lordship. And in phased manner, the remaining employees will be regularized. That is the decision taken sometimes back in the year 2021, Lordship. Now, those 500 has already been regularized and the regularization process of the others are pending, Lord. In the meantime, this PIL came, Lord. So we have already filed our affidavit, Lordship. They have filed a reply yesterday, Lordship. Probably it is not in the record. So Lordship will take up this matter and conclude, Lordship.
You also don't want it to be closed today. All right. Ms. L. Devil and counsel for the petitioner submits that the affidavit in reply filed on behalf of our client yesterday is not on record. Mr. P. Nayak Lanet SCGMC, however, submits that he has received copy of the affidavit in reply. So is the submission of Mr. L. Das Lanet, Government Advocate Assam, appearing for the state. In view of the above submission, register to tag the affidavit in reply with the record of this case and list the matter again after 4 weeks.
Obliged, Lordship.
Item 26.
My lord, in this, we have served the SR is completed, but only say for five, respondent number 5 and 6, others hasn't filed any affidavit as yet. So the matter will be fixed for hearing.
My lord, I'm appearing on behalf of respondent number 9 and 10. We need a two weeks accommodation for filing our affidavit in opposition.
I'm preparing for respondent number 8.
You filed your,
So we'll file now. For respondent number 6, we also file that.
Respondent number 5 has filed. 6 also, we have also filed a reply to their affidavits.
Acha, this PIL has been admitted. Has it been admitted?
The service was complete as a day probably.
Service is completed.
I'm asking whether it is admitted. You are saying service is complete. What is the meaning of this? Can the answer to has it been admitted be service has been completed?
The service has been completed. Oh, that is the admission hearing is not yet done.
Not yet.
Not admission.
Finally, there is someone who has given a reply.
Yes, my lord.
See, just imagine what we have to go through every day. Something is asked, something else is answered. What is this matter about?
My lord, actually, our allegation, we are ordinary resident of the Palasbari revenue circle area. And my lord, because there were some construction has been done blocking the natural water flow, actually. So the water which hill water, rainwater, which is supposed to flow to Dipperville or to Brahmaputra, has been blocked in certain ways, my lord, because of the construction of the walls. I mean, I have submitted some photographs also in this matter, and then we have given, actually, my lord, we have taken some RTI also from PWD department, and they also submitted the same thing. I have submitted one, we received it later on 4/1/2024, and because it came to us late, so we filed another affidavit in this regard also, and then we submitted that report. PWD also said that they have some mischievous construction has happened, like walls and everything. So the water part which was been, these bridges were been blocked, basically the waterways through which. And respondent number 6 said like they have purchased the land and all this, but then they cannot block the natural flow water. That is our only concern, sir, my lord. And then because of this, like in the nascent flood rain also, a lot of flood situation happened in that particular area.
Who is appearing for 1 and 2? Yes. What is this? People are in distress everywhere. There is water logging.
Respondent 1 and 2, Lordship, the affidavit.
Forget the affidavit. Is it a case that water is being blocked and then, what do you mean by no? It's everywhere visible. There's a 1 hour rain, every area is under water. And you say no. Then yes, affidavits and PILs and orders are of no use unless the people get the relief. Where is the relief going to come from? It's turning into a hell whenever there is a rain. Everybody is suffering, everybody is affected. No, we are not just blaming the authorities without our objectivity, but somebody has to do something about it. So you are filing affidavit, they are making allegations.
My lord, I have got the photographs also, like I have submitted it in the, it's very distinctly seen, like the waterways are clearly blocked. They have constructed views, concrete.
Who has constructed that?
That is, I think this is, respondent number 6. And still construction works are going on.
Who is appearing for respondent? Then we'll appoint a advocate commissioner.
But then this is how our information is this, because they have constructed and I have got this. I have also filed in page number 119. No, this would be page number 199. Yes, my lord. That is, I have submitted a report.
Then we will send an advocate commissioner.
Please, that will be great. Yes, my lord.
And both of you, are you willing to pay some
Yes,
remuneration to the advocate commissioner?
yes.
We'll send a commissioner then
Okay.
and to give us a report. Where is Mr. Anjan Kalita? Can you call him? Mr. A. Kalita. Just wait for 10 minutes. We'll take up the man.
And 27 and 28.
But item 28 may be taken, 28. My lord, in prayer, my lord, prayer A, my lord, I may be granted liberty to withdraw the same prayer A, my lord. There I have changed the rule, my lord. Others, my lord, let the matter be remanded to a single bench, my lord. There I have rule, challenge the rule. That may be withdrawn, my lord.
Achha, that is in WPC number?
2151.
Okay. Take down in WPC 2151 of 2023. Who has not come to you? Chaudhary has not come. Who has not come?
Second row. Oh, second row. এই পাত্র এটো উইথড্র করলে মই সিঙ্গল বেজে বসে যায় আর এটো 27 টু একটু নকরে যদি হিয়ারিং নকরে আমি উইথড্র করব এটো উইথড্র করব এইটো বেলেগ বস্তু
You right, Mr. B. Sinha, learned counsel appearing for the writ petitioner, submits that the first prayer in this writ petition, which seeks to challenge the validity, submits that his clients are not pressing the first prayer in the writ petition, assailing the validity of Rule 6, bracket 6, bracket close, bracket B, small b, bracket close, of the Assam Ministerial District Establishment Service Rule, 1967, as well as the amendments made to the rules. Full stop. However, the remaining prayers are being pursued by the petitioners. Full stop. from a reading of the prayer portion, we find that this writ petition has been posted before the division bench only because provisions of Rule 6 bracket close small b bracket close was under challenge. Otherwise, this matter is required to be taken up by single bench as per roster. Mr. S.K. Talukdar, learned counsel for the respondents, has also confirmed the said position. In view of the above, let this matter be posted before the learned single judge along with WPC number 2351 of 2023.
Item number 27 is different one, is a challenging rule, different rule, might.
Acha. Then
11 may be remain,
along with-
27 may remain.
In view of the above, this writ petition shall be segregated from WPC number 2351 of 2023 and listed separately. Done. Then in item 27, you write, segregate this writ petition from item 28 and list the matter after 4 weeks separately. Yes, call that man. Mr. Kalita? So there is some dispute regarding a construction having been made by a plywood industry, which is creating artificial flooding, waterlogging. Which area is that?
Polasbury area.
Polasbury area. Now, these are factual disputes, but these issues are of serious public inconvenience. So we want to appoint you as amicus. You have to visit and submit a report. Right? And you will have to bear expenses,
cost, yes.
a remuneration for the amicus. 50-50, both of you. What is the amount? Both of you together pay 50,000 rupees to Mr. Kalita. For a visit, he may have to visit twice with his junior and also have to prepare a detailed report and submit it. But it has to be done expeditiously. Within
1 month time,
1 month is too long.
1 month. Long.
Express service.
Then there is a
That's why,
1 month you will be required, maybe not so.
no, you do it before vacation.
For vacation.
Before, we'll fix it on 30th of September. If you want extension, then you tell us then. All right. You take down. Heard Miss G. Goswami, Mrs. S. Goswami, learned counsel appearing for the PIL petitioner. We have also heard her give the list, entire list, all of them. The basic issue projected in this PIL is to the effect that due to some illegal constructions raised by the respondent number 6, blocking the natural waterways in the Polasbury area of Kamrup district, whenever there is rainfall.
I don't, not only number 6, there are some other construction of the other respondents also.
Number 6 and
6 is very specific that I know. And my lord, others also has done constructions there.
others 6, 7, 8 and 9, is it?
Yes. 9 and 10. 9 has raised.
6 to 10, blocking the natural flow of drain water.
Yes, rain.
Whenever there is rain in that area, the citizens have to face massive problem of waterlogging, thus posing enormous difficulty for them in their day-to-day life. Full stop. According to Ms. Goswami, despite representations having been submitted before the authorities, no effective steps have been taken till today to address the grievance of the petitioners. Full stop. The petitioners council have also submitted that for carrying out a fact-finding exercise, if necessary, a court-appointed commissioner should visit the site and submit a report. Full stop. Mr. P. Das, Learned Counsel for the respond number 6, and Mr. B. Yadav appearing. And you are Acha. Mr. Chaudhary for respond number 8 and Mr. B. Yadav appearing for respond numbers 9 and 10 have also agreed
Respondent number 7 hasn't appeared.
that
Annapurna.
while denying that their clients have raised any artificial construction of permanent nature blocking the drainage, have agreed to an order from this court appointing an advocate commissioner. Full stop. Then you all will pay the fee. Why should we burden the petitioners? A petitioner will only provide for the transportation cost, etc. Mr. D. Gogoi, Learned Standing Counsel, Forest Department submits that his clients have no role to play in the matter. First of Ms. N. Bordole, Learned Standing Counsel, Revenue Department, Assam, has submitted that the stand of the authorities are reflected in the affidavit. Be that as it may, after hearing the submissions of Learned Counsel for both the parties, we appoint Mr. Anjan Kalita, advocate, as amicus curiae in this case to assist the court system. Register to furnish all papers connected with this case to Mr. Kalita within a period of 10 days from today. First up, upon receipt of such papers, Mr. A. Kalita may visit the site and carry out necessary inspections, besides interacting with all the stakeholders, including the petitioners, the private respondents, and the departmental authorities, and thereafter submit a report. Full stop. We'll make it like this. The respond number 6, 8, 9, and 10 shall pay a sum of rupees 15,000 each to the learned amicus curiae as fee for carrying out the inspection. Full stop. Likewise, the writ petitioners will jointly pay an amount of rupees 15,000 to Mr. Kalita so as to cover his professional expenses as well as travel and other costs. Full stop. Upon carrying out such inspection, Mr. Kalita to submit a report before this court in seal cover on or before the next date fixed, register to list this matter again on 30th of September.
Let's say, I have a small pay. Let's say, can the documents can be given to me a little bit earlier rather than 10 days?
Within 7 days. Within 7 days.
Yes. She can also provide me the documents.
We may be allowed to file our in the meantime, the respond numbers 9 and 10 are granted liberty to file their objections. We make it clear that the order appointing the learned amicus curiae as well as the directions to pay remuneration to him in the above manner is passed with the consent of learned counsel for all the contesting parties.
Publish.
Item 29.
May I please proceed? The prayer of the petitioner has already been, my lord, redressed. On, my lord, 5/8/2024, the online portal of RTI under section 4 has been inaugurated.
Online portal of RTI has been made operational.
My lord.
Lord, there was two parts. One was online portal, another was section 4 mandatory disclosure of information. The section 4 mandatory disclosure of information criteria has not been as far as mentioned, like met till now. And another thing, I did file a sample RTI on the portal, my lord. The thing is over there is till now, even if you try to file an application online, they don't allow so, and what they want is they want a written signed copy of the RTI to be uploaded. So in itself, it makes the entire process futile.
All right, the petitioner and counsel, petitioner in person, Mr. Ritam Singh, has appeared and submitted that after the filing of this PIL, although an RTI portal has been made operational, yet there are certain bottlenecks in the functioning of the same, which needs to be streamlined by orders passed in this proceeding. Mr. D.K. Sharma, learned additional senior government advocate Assam, has confirmed that the online portal is now operational. However, as regards the complaints, as regards the additional complaints of the petitioner, Mr. Sharma submits that he be granted some time to obtain instruction and address this court. First up, prayer allowed. Mr. G. SCGH.
Section 4, my lord, the section 4 requirement is not been met by the Guwahati High Court, where mandatory disclosure has to be made on the website of the High Court.
That is well, they'll obtain. Acha. Mr. So-and-so for respondent number 2 and Mr. So-and-so for respondent number 5 are concerned. On the next date fixed, the learned counsel for the respondents to obtain instruction and address this court as to whether the requirement for
Section 4 guidelines, Section 4 compliance. There has to be Section 4 compliance and the online
Section 4 of what?
RTI Act 2005.
As to whether necessary steps for compliance of Section 4 of the RTI Act has been initiated while operating the online RTI portal.
Deeply obliged, my lord. Deeply obliged.
Item 30.
This matter pertains to non-payment of family pension and the past twice, my lord. On the last occasion on 13/8/2024, there was an order passed by this honorable court.
So, we have already revalidated the pension PPO.
It's only revalidated, my lord. No information we have received from the treasury, my lord, because as per the last order,
So what is to be done?
The Lordship, if I may, Lordship, the Treasury officer is, I've just had a word with the Treasury officer. Once the petitioner visits, they can visit today also. Tomorrow is a working Saturday, Lordship. If they visit tomorrow also, the grievance of the petitioner will be addressed, my lord. There is some certain documentation needs to be done. So if she visits, the petitioner visits once, because the revalidated copy they have received. Whenever my learned friend it's convenient. They can just.
Pursuant to the order dated 13/8/2024 passed in this proceeding, the senior accounts officer of the Office of Principal Accountant General (A&E) Assam has revalidated the FPPO pertaining to the writ appellant. First up, Mr. R.K. Talukdar, R. Boro, learned Standing Counsel, Office of AG Accountant General, has produced a copy of the communication dated 14/8/2024 in support of the above contention. We have perused the same. Mr. Biswas, learned counsel for the appellant, submits that notwithstanding the revalidation of the FPPO, no amount has been received by his client till date. At this stage, Mr. A. Chalia, learned Standing Counsel, Finance Department, Assam, submits that 1 or 2 documents will have to be signed by the appellant before the amount is released. And therefore, if she visits the concerned treasury officer any day, the amount due shall be released to her
as soon as possible.
after obtaining her signature. Full stop. As a matter of fact, Mr. Cholia has even suggested that the appellant can visit the concerned treasury officer even today in the course of day or any other working day in the course of this month. Full stop. So we'll close it then.
No, it may be kept pending, my lord, because she resides in Tezpur. She has to visit the Lakhimpur.
On the request of Mr. Biswas, Learned Counsel for the appellant, this matter is directed to be posted again on 20th of uh, 20th of September, so as to enable Mr. Biswas to obtain updated instructions.
Right. Much obliged.
Item 31.
Lord, you will receive the instruction. I want to begin through an affidavit.
Mr. S.K. Talukdar, Learned Counsel is present for the appellant. On the request of Mr. N. Das, Learned Government Advocate Assam, who submits that he has received necessary instructions and will file affidavit within a week's time. This matter stands adjourned for 10 days. Ms. N. Bordole, Learned SC Revenue Department, Assam, and Mr. R.K. Boro,
For decimal 2, 3, 4, and 5.
Learned Counsel for respond numbers 2, 3, 4, and 5 are also present.
Any of after 25th of September, my.
After 2 weeks.
Nice shot. Item 42.
My lord, the-
The other side was supposed to take time today.
my lord, I prayed for time
This
to.
side is supposed to take time, and now he is refusing to take time. What to do?
No, my lord, we have informed, my lord, they have, in fact, that we will file affidavit, my lord, we have received the paravise comments.
Mr. H. Gupta, Learned CGC submits that Learned CGC appearing for the respondent submits that he has received the paravise comments and therefore we granted 2 weeks time to file affidavit. Since the prayer is not opposed by the petitioner's counsel, same stands alone. Let the matter be listed after 3 weeks. In the meantime, counter affidavit be brought on record.
Item 33.
May I please, your lord?
Yes.
Lordship, the matter relates to challenge of two provisions of an act, my lord. They are supposed to file affidavit. Affidavit is not filed, my lord.
So who is appearing for the respondent? So we'll close the pleadings then on your submission that no pleadings is required. Heard Mr. S. Alim, Learned Counsel appearing for the writ petitioner. Also heard Mr. N. Das, Learned Standing Counsel, Learned Government Advocate Assam, appearing for the respond numbers.
Here I am appearing for one.
You have 4?
One. Government advocate.
Acha. Ms. R.V. Bora, Learned Government Advocate Assam, appearing. Traditional Senior Government Advocate Assam, appearing for the respond number 1. Who is for 2 to 4?
Education.
Who is the Standing Counsel Education? Give her name.
Education department.
And Miss A. Das, Learned SC Education, appearing respond numbers 2 to 5. None is present on behalf of respond number 6. In this writ petition, the provision of section 7 bracket small a bracket close and small b bracket close of the Assam Elementary and Secondary School Teachers bracket Regulation of Posting and Transfer bracket close Act, 2020 has been challenged. First up, the Learned Counsel for the respondents have submitted that they do not have any instruction to file counter affidavit in this matter. If that be so, this writ petition shall be deemed to be ready as regards pleadings. Having regard to the nature of issues projected in the writ petition, the matter will require detailed consideration. As such, admit the writ petition Since the parties are already represented, no formal notice. Since the contesting parties are already represented, no formal notice. Registered to list this petition for hearing in usual course.
I'm highly obliged, my lord.
Item 34.
Here also cleaning is complete. My friend filed also affidavit also.
Hmm?
Matter ready for hearing also.
Lordship, I have some preliminary objection in this matter, Lordship, against the writ petition. Those things may be, those preliminary objections may be kept open and ultimately heard. Otherwise, my preliminary objections are, Lordship, first of all, the prayer is defective. Prayer is defective. They have challenged an order stating to be an order in the way before the learned tribunal, which in fact is not an order of the tribunal. Then, Lordship, order in contempt petition.
Preliminary objection on what ground?
First of all, Lordship, will kindly have a look at the prayer, Lordship.
That's not a preliminary objection.
Then they have challenged the order in contempt petition. An order of contempt petition has been challenged. But contempt petition, if they want to challenge an order in contempt petition, the forum is the Supreme Court, Lordship. To that effect, I have judgment and law
That's the
also.
only thing under challenge.
Then, Lordship, there is delay also. No, another
Which
order.
order under challenge is the order in the contempt case.
And another order, the order in the OA is also under challenge. That order is dated 4/8/2017.
Then it's not a question of maintainability. You said maintainability.
Maintainability.
Maintainability, if there are other orders challenged, then the writ petition cannot be dismissed on maintainability ground. What else is the other ground?
4/8/17 order they have challenged. That order is, Lordship, 7 years old. They have
All
approached this
merit.
order.
These are all merit.
Then it is a consent order also otherwise.
Then you argue it on merit, we'll hear it. We'll hear the matter. Readings are complete.
All these things may remain open. Preliminary objection may also be heard at the time of hearing.
What is the issue about?
Here we have challenged the lordship, the honorable tribunal, so that lordship, where honorable tribunal granted lordship antedating seniority lordship. That part we have challenged.
This matter will require hearing.
Hearing, yes.
Has it been admitted?
Lordship admitted lordship. Yes, sir.
But Mr. K. Gogoi, learned counsel appearing for the writ petitioner, also had Mr. G.J. Sharma, learned counsel appearing for the sole respondent. Stop. This writ petition has already been admitted. When was it admitted? Don't just say things without knowing, huh? This is not a good habit. Writ petition has been aligned. Right there. It is submitted at the bar that this matter is ready as regards pleadings and can be taken up for final disposal. After hearing the preliminary submission of learned counsel from both the sides, we are of the view that the issues projected in the writ petition would call for detailed consideration. As such, admit the writ petition. Since the respondent is already represented, no formal notice is required to be sent in this case. Register to list this matter for final hearing. Any urgency? In the month
He
of
has retired.
December 2024.
Oblige.
Item 35.
Yes, please, Lordship. Lordship, we have filed the affidavit in line, Lordship, paying for the date of hearing, Lordship. We have filed the affidavit in line, Lordship.
We have already filed affidavit.
The writ petition has been admitted.
Not, my lord. Notice issued, my lord.
What is the matter about?
Matter is regarding, my lord, earlier he was removable from service. Subsequently, he placed before the departmental authority, compulsory retirement awarded. Then he went to care. CAT said that give lesser punishment. Then ultimately he is reinstated. But regarding the period from 2013 to 2020, that period is kept as dies known. Now she again claiming the salary for that period. That was dismissed by the CAT. But challenging that CAT order, yes, come.
So it will be no punishment. Earlier removal, then compulsory retirement. If already reinstated in service, now again if the salary. Are you ready to argue finally today?
Currently our station, he will
Who is
be
your senior?
Adil Ahmed.
Sorry?
Adil Ahmed, sir.
We thought we'll allow it today. Not ready. Next day dismissal.
Pray for last chance, hearing.
You missed out a chance. Now you will not get. Miss, your name please?
A does not.
Chief Learned Counsel is present for the petitioner. Mr. K.K. Parasan, Learned CGC has appeared on behalf of the respondents. After hearing the submission of Learned Counsel for both the sides, we are of the view that the matter would call for detailed consideration. As such, admit the petition. Since the parties are already represented, no further notice is required to be sent in this case. Let this petition be listed for hearing in usual course. There is no urgency in the matter.
For hearing, I will.
Hearing, final hearing matter. Why hearing on Friday? Why hearing matter is fixed on Friday?
I didn't get you what your lordship is saying.
What is this case?
Worship, was listed a few days back, I was not present, somebody had mentioned on my. So it was fixed today, maybe almost say on.
What is this matter about?
To understand this matter in a very easiest way, your lordship will just find what the contention in this
Right.
petition. I will just take 5-10 minutes.
This is not
to
the
clear-
right day to do a final hearing. Friday, last Friday.
I will just take 5 minutes to clear entire thing, entire aspect of this
But
petition.
also tell us the date when the matter can be heard.
Yes, yes. I will just take 5 minutes.
Then why are you take, actually you take 5 minutes, you take 10 minutes. But when
So-
you conclude your submission,
Yes.
tell us a date very soon when we can post the matter for final hearing.
Last week of this month, any date. Because this is a long pending
So
matter.
what is the issue? Tell us.
The issue is your lordship will find. In 2012, the government of India did a census. One census is known as population census 2011 and another is caste census, socio-economic caste census 2011. So now as per 2011 data, Assam has a transgender of 11,374. Whereas in socio-economic caste census, the numbers which has been enlisted by the government So now when the state community persons, they went to the concerned officer and they asked for the schemes where they can get themselves enrolled to get themselves benefited. So the government denied.
Government means state government.
State government denied. The state government replied to the community by saying that this is a central government scheme. We are only the implementing agency. And this entire process is based on socio-economic caste census. Means the data which has been recollected in the socio-economic caste census 2011, only they will be benefited under that scheme. So if they will be benefited under that scheme, then again the contradiction comes. The 2011 population census says the Assam has a transgender population of 11,374. How that data got reduced by 1,500 or 1,700 in socio-economic caste census? This is the first thing. In the meanwhile, the Assam government and the government of India, the Assam government formulated Assam state policy for transgenders. In the meanwhile, the government also enacted a new law which is known as Transgender Person Protection of Right Act 2019. So under that act, section 15 clearly enumerates that what are the health measures that are required to be taken up by the state government and by the central government, which are being categorized as the appropriate government definition. Even though the government of India is silent on their part, the government of Assam is silent on their part, there are many affidavits which are being filed on behalf of government of India, stating that we are coming up with a new SMILE project. Now, even though the project was launched, but we see nothing on the ground. The state government says that we have made a 6-ward separate rooms for the transgender persons to be benefited and under this health insurance scheme. I personally visited Guwahati Medical College and I found there are no such wards has been made separately. So now our concern is, as because this is a very long pending matter, and most of the time the community person, they don't get the health benefit policies or schemes. So in that regard, if any seriousness takes place, suppose any transgender who meets with an accident or requires a critical care, in that regard, under which scheme we will be treated as, the community will be treated as. So this is our main concern. So therefore, what was upheld by the Honorable Supreme Court in the Nalsa judgment, and this act talks about, this is what the government of India and state government has to be implemented in letter and spirit. Otherwise, this is a clear violation of right to life, Article 21 of the Constitution.
All right, now we do agree. You're raising some very serious issues, and these issues will have to be addressed.
Yes.
But more than interpretation of law, this is more of putting a system in place which actually responds to the need of the community as and when it is required. So what we're proposing to do is, we would request the Learned Advocate General, Mr. Saikia, to please assist the court in this matter. Please communicate to him. Let him come in this case. Mr. Chaudhary, you also look into it. We think this is not a matter where adversarial stand is required. We'll try to sort out the problem and see how the concerns of this community is addressed at the earliest. That's right. That's right. So let us get a clear picture of what is happening and which way things are going. Now, whatever is feasible and necessary to be done, we'll do it. To expedite things, it's better to have apex level counsel. Maybe the Advocate General Assam will be in a better position to tell us. So,
Only just 1 minute. If your lordship just go through this act, that section 15 clause G is very clear. It says what are the existing health schemes or policy which have been formulated by the state government or by the central government. The community has to be included under that.
heard Swati Bidhan Barua, petitioner appearing in person in this case. We have also heard Mr. R.K.D. Chaudhary, Learned DSGI, appearing for the respond number 3. Mr. D. Upamanyu, Learned Standing Council Health, has appeared for respond number
1.
Respond number 2. And Ms. R.B. Bora, Learned Government Advocate Assam, for respond number 1. Acha. So whose name should we record? Acha. Ms. A. Chaume, Learned Council, is present on behalf of the respond number 4. The issue raised in this PIL, reduced to its essence, pertains to the apathy on the part of the institutional authorities in their failure to address the medical needs of the members of the transgender community permanently living in Assam, more particularly when it comes to facilities of reconstructive surgery. Full stop. The petitioner submits that although there is a central government scheme permitting the members of the community to avail the benefits of such reconstructive surgery due to lack of proper guidelines and clear instructions, neither the central government nor the state government of Assam is coming up with concrete measures so as to redress the grievance of the community, members of the community. Full stop. The petitioner has further argued that due to such confusion prevailing in the matter, the rights of the members of the transgender community, not only the rights of the members guaranteed under the of the transgender community guaranteed under section 15 bracket G small g of the Transgender Persons bracket Protection of Rights bracket close Act, 2019 being violated, but the fundamental right of the community members as guaranteed under Article 21 of the Constitution of India is also being breached. First step. After hearing the submission of the petitioner and upon going through the materials placed on record, we are of the view that the concern raised in this writ petition is of serious nature and calls for immediate redressal. Full stop. Instead of treating the issues as of adversarial nature, what is necessary is to find out ways and means and thus proper solution so as to address the grievance of the members of the transgender community within the legal framework existing in the country and in furtherance of the schemes framed by the central government and the state government to that end. Full stop. With that objective in mind, and considering the nature of issue involved in this matter, we request the learned Advocate General Assam, Mr. D. Saikya, to look into the papers and render assistance to this court in the matter on the next date fixed. The learned DSGI may also obtain specific instruction on the issues flagged in this order and address this court on the next date fixed. Mr. D. Upamanyu, learned Standing Council Health, to furnish a copy of this order, to bring a copy of this order to the notice of the learned AG Assam. First up, registry to list this case again on, choose a date.
Last week of this month, any date.
Is the matter again on.
But after 20, your lordship, because from 11 to 20, I will be in SC.
On 26th of September, 26th of
26 will
September,
be fine.
by reflecting the name of Mr. D. Saikya, AG Assam in the cause list. You brief him in the matter. All right. That's all.
Yes, highly obliged.